ದೂರ ಕಟ್ಟದು ಎಲ್ಲ ಕಾಣ್ತದೆ ಊರೊಬ್ಬರು ರೋಸಲ್ಲಿ ಯಾರು ಊರೊಬ್ಬರು ಎಲ್ಲ ಕಾಣ್ತಾನದಾರ ನೋಡಿ ಇಲ್ಲಿ ನೋಡ್ಕೋತ ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಮೀಟಿಂಗ್ ಮಾಡಿದ್ರಾ ಓಕೆ
Page 1, page number 1 to 6, page 2, 7 to 10, page 3, 11 to 19.
ಇಲ್ಲಿ ರಾಜು ಏನ್ ಎಣ್ಣೆ ಆಗ್ತಾ ಇಲ್ಲ ಇದು ಸ್ವಲ್ಪ ಕೇಸ್ ಇವತ್ತು ನೀವು ಎಲ್ಲ ಡೇಟ್ ಇದು ಕೇಸ್ ಅಡ್ಮಿಷನ್ ಇದೆ at the request of appellant counsel 2 weeks time granted. Finally. No, I'll hear it. Then I will hear the issue. Misplace ಆಗೋದು 13 ವರ್ಷದಿಂದ ಕೇಸ್ ಅದು ಕಳೆದ ನಮ್ದು ಮಿಸ್ಪ್ಲೇಸ್ ಆಗುತ್ತೆ. I told you last time, I think. Last time also I told you. It will miss all ನಮ್ಮಲ್ಲಿಂದ ಮಿಸ್ ಆಗ್ಬಿಡುತ್ತೆ. It will miss from High Court itself. 14 ವರ್ಷ 15 ವರ್ಷ ಕೇಸ್ 2011 ಸರ್. No. Court notice issued to the appellant counsel Satish Chandra. ಯಾರು ಕೋರ್ಟ್ ನೋಟಿಸ್ ನೋಡುತ್ತಾರೆ ಅವ್ರು ಯಾರು ಬರ್ತಾ ಇಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡುದು ಅಷ್ಟೇ. ಪಾರ್ಟಿನೂ ಬರ್ತಾ ಇಲ್ಲ ವಕೀಲು ಬರ್ತಾ ಇಲ್ಲ. ಕೇಸ್ ಈಗ ಬಂದ್ರೆ ಹಿಂಗ 10 ವರ್ಷ 11 ವರ್ಷ ಬರ್ತಾವು ಫೈಲ್ ಇಲ್ಲ ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ ಕೇಸ್ ಹಿಂಗಾದ್ರೆ ಹೆಂಗ ಏನ್ರಿ 12-13 ವರ್ಷ ಕೇಸ್ ಎಲ್ಲಿ ಸಿಗ್ತಾವು ಕಳೆದ ಹೋಗ್ತಾವ ನಮ್ದು ಕೇಳ್ತಾವ ನಿಮ್ದು ಹೋಗ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಯಾರು? ಕೃಷ್ಣಮೂರ್ತಿ ಬರ್ಲಿ ತಡಿ ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ. ಇವ್ರು ಯಾರು ಅಪ್ಲೆಂಟ್ ನಿಮ್ಗೆ ಡೇಟ್ ಕೊಡ್ತಾನೆ ಡೇಟ್, ಬಟ್ ಅವರು ಬರುದಿಲ್ಲ. ಅವ್ರು ಆರ್ಗ್ಯೂಟ್ ಮಾಡ್ಬೇಕು, ಪಾರ್ಟಿಗಳು ಬರುದಿಲ್ಲ. ಬರುದಿಲ್ಲ, ಅದಕ್ಕೆ ಡಿಸ್ಕಸ್ ನೋಡ್ತೇನೆ. ಅದ ಬಂದ್ರೆ ಒಂದ್ ಡೇಟ್ ಕೊಡ್ತೇನೆ, ಡೋಂಟ್ ವೆರಿ, ಬಟ್ ಬರ್ಲಿ ಅವರು. ಅಂದಾಗ ಒಂದ್ ಡೇಟ್ ಕೊಡ್ತೇನೆ, ಬರ್ಲಿ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ. ನೆಕ್ಸ್ಟ್ no representation for appellant. 2 weeks granted finally for compliance of office objection. Yes. The request of appellant counsel 2 weeks time granted. Yes. Weeks time granted finally at the request of. ಇದು ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಆಮ್ಯಾಗ ಕ್ಲಬ್ ಮಾಡೋದು. ಮೊದಲು ಕಂಪ್ಲೈ ಇದೆ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್ ಫಸ್ಟ್ ಅದ್ ಮಾಡಿ ಆಮ್ಯಾಗ ಕ್ಲಬ್ ಮಾಡೋದು. ನೆಕ್ಸ್ಟ್ ನೋಡಿ ಇವ್ರು ಎಂತ ಬರ್ತಾ ಇದ್ರಲ್ಲ ಅವು ಕೇಸ್ಗೆ. ನೋ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ಅಪೆಲೆಂಟ್. ಲಾಸ್ಟ್ ಟೈಮ್
no representation 3 weeks time. Last
we've seen that previous date also. It is seen that we seen that previous date also there is no representation. Two weeks time granted finally to stop. If office objections are not complied, the appeal will be dismissed.
Number 5.
Date ಕೊಟ್ಬಿಡ್ತೀರಿ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರ. 2 weeks ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ಬಿಡಿ.
Number 5. Current DT.
ಇದು ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ. ಲಾಸ್ಟ್ ಅನ್ನಲ್ಲ
Non-compliance 55, serial number 6. Ramesh Gowda, MK for appellant.
Time. ಯಾರು ಗೊತ್ತಾಗ್ಲಿ. But if there is no representation, that is will be dismissed on Barwa. There is no representation for appellant. There is no representation for appellant. Previous date it is made clear that if compliance is not made, petition will be dismissed. Full stop. But today also there is no representation. It shows that appellant is not interested in prosecuting the appeal. Hence, the appeal is dismissed for non-compliance of office action. Yeah.
First matter, serial number 7. Kumara KG for appellant.
Sorry. That one minute is first death abet madam. The police report, Ellen police report is the police report. Let me press it. Huh? R9 ಹೆಸರು ಏನ್ರಿ? What is name of R9? The police inspector, Sira Town Police, has submitted a report stating that respondent number 9, PJ Pandurangappa. Pandurangappa died on 2/11/2015. The certified copy of book death certificate is also enclosed. In view of death of respondent number 9, the appeal against respondent number 9 stands abated. Appellant counsel yaru Kumar KG ಬರ್ತಾ ಇಲ್ಲ ಸರ್ ನೋಡೋ ಲಾಸ್ಟ್ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್. ಉಳಿದವ್ರಿಗೆ ಏನಾಯ್ತು? ಅಪೀಲ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ? 2 to 5 and 18 ಅಲ್ಲ?
So like in the 24 and 28. But order dated 21/10. That is one instance. So
Appellant side no representation. The order sheet shows that continuously for more than 2 years, the appellant counsel has remained absent. Even the appeal against respondent number 2 to 5, 18, 21, 24 and 28 was already dismissed by order dated 21/10/2022. as no steps were taken by appellant. Full stop. Today, the appeal against report number 9 also dismissed. So it shows the next. The respondent counsel presented and submitted that this appeal is prepared against we've seen that this appeal arises out of dismissal of complaint dated 8/9/2017 by Second Additional District and Session Judge Tumkur for non-prosecution. The certified copy of the order sheet reveals that a private complaint was filed. ತಿಳಿತಿದ್ದಲ್ಲ ಇವ್ರೆ ಗೊತ್ತಾಗಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ ಮತ್ತೆ ತಪ್ಪು ಇದು under section 200 CRPC alleging the offense under section 420, 467, 465, 468, 471 IPC read with section 13(1), 13 bracket the 1 bracket A capital A and 13 bracket 2 13 subclause 2 of Prevention of Corruption Act. The order sheet shows that the matter is registered as PCR and the case was posted to hear the complaint side as to whether the matter is to be referred for investigation. And it full stop. It appears the complainant counsel remained absent on several adjournment. Subsequently, the complaint came to be dismissed. On 8/9/2017. Stating that the complainant and his counsel are continuously absent in several hearings. Hence, it is seen that the complainant is not interested for prosecuting the complaint. Accordingly, the complaint is dismissed. Next paragraph. It is seen here also the appellant or his counsel are present. The case is already dismissed against several persons. Next paragraph. It is also seen from the nature of order that the case is still at pre-cognizance stage and still the and also at the stage of pre-issuance of summons. The order sheet shows the court has neither taken cognizance nor issued any summons. Therefore, the nature of order of dismissal will not amount to acquittal of the accused under section so as to file the appeal under section 378 CRPC. It is only if the summons is issued and summons is ordered to be issued to the accused and any subsequent date of hearing, the complaint remain absent, then it is the discretion of the court to dismiss the complaint under section 256 CRPC. To stop. Further, if a private complaint is filed, the court can either record source statement by taking cognizance or refer it for investigation by police. If the court refers the matter for investigation, the court has to await report of the police. If the court decides to take cognizance and proceed further under the provisions of section 200 CRPC, then after examining the complainant and his witness, if any, and considering the material on record, if it is found that there is a prima facie case to issue summons to the accused, then under section 200 3 CRPC 200 under section 204 CRPC issue process. If after considering the statement on oath and result of inquiry under section 202, if there is no sufficient ground for proceeding, the magistrate, the magistrate shall dismiss the complaint by stating brief reasons. Full stop. Therefore, here the appeal itself is not maintainable under section 378 subclause 4, as there is no acquittal of the accused, as stated under section 378 for CRPC. The office has to carefully scrutinize the file and raise such objections whenever this type of appeals are presented. This matter is pending unnecessarily for nearly more than 5 years without there being either complainant or his counsel present. This is nothing but abuse of process of court. Therefore, the appeal is dismissed as not maintainable. Appeal is dismissed, appeal not maintainable at all. They have to file 482 petition, if at all they want to restoration. Otherwise, appeal not maintainable. Dismissed. Okay. Need a madam. Third what complaint and is a counsel option. Third alert cost for respond and so there is the file and the detail order. Okay. In my sir, you are for respond number 16 16 dismiss Srinivas, M. Srinivas respondent 16 counsel present. For R10 K. Krishna for respond number 10 presented and stated that appellants are not coming and appeal be dismissed. Okay. Appeal against so and so is already dismissed. Not taking steps. So today, appeal against 9 is ಯಾರು dismissed as abated. Next.
Number 8. Mr. Narayana B.S. Appellant.
Appellant counsel praise time. 2 weeks time granted. Finally is the last chance.
Number 9. Jagat Kumar Shetty.
5 ವರ್ಷ ಆತಲ್ರಿ ಇವ್ರು ಯಾ ಹ್ಯಾಂಡ್ ಎಲ್ಲಿ ಸಿಗ್ತಾನ ಸುಳ್ಳ ನೀವು ಸುಮ್ಮನೆ ಹ್ಯಾಂಡ್ ಅನ್ನು 18, 19, 20, 21, 22, 23, 6th year. ಇರ್ಲಿ 6 ವರ್ಷ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ನೀವು ಅಪೀಲ್ ಏನ್ ಎನ್ಐ ಆಕ್ಟ ದಿಸ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್. ರೇಖಾ ಜೆ ಶೆಟ್ಟಿ, ಹಕೀಂ ವಾಸಿಂ, ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟರ್ ಐಕೋರ್, ರೇಸರ್ ಟೌನ್, ಬ್ಯಾಂಗ್ಳೂರ್. ಇದು ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ 212 ಕೊಟ್ಟಾರ. ಅದು ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಪ್ರತಿ ಸಾರಿ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಪ್ರೆಸೆಂಟ್ ಇಶ್ಯೂ notice to respondent to the address furnished by the appellant counsel, and also at the same time the appellant is also permitted to serve the notice. Actually criminal da illa service, personal service, civil da ishte ಇದೆ. Yes.
What you see for appellant?
ಯಾವ್ದು ಹೇಳ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1063. ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರ ಹೆಸರು ತೋರಿಸಿಲ್ಲಲ್ಲ. ಹೂ ಇಸ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್? ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿದಾರ ನಲ್ಲಿ ನೋಡಿ ಎಲ್ಲಿದೆ? ರಾಜು ಪಿ 1063. ಅಲ್ವಾ? ಓಕೆ, ಅದಕ್ಕೆ ಕೇಳಿದ್ರೆ ಎಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಬರ್ಲಿ, ಏನಾಗಿದೆ ಬರ್ತಾನೆ ಆದರ್ಶಿಪ್ ಏನಿದೆ ಯಾರು ಬರ್ತಾನಿಲ್ಲ. ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಅಡ್ರೆಸ್. ಇದು ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಆಗಿದೆ. No representation for appellant. Two weeks time granted as a last chance, in which the appeal will be dismissed. 2 weeks time for taking steps if the address is not furnished and PF is not paid, the appeal will be dismissed. Yes. Next. No representation for appellant. Same order. 2 weeks time period. Finally, the last chance, in which there will be dismissed.
Hearing on interrupted application. Till number 12. Asking Sadar Chorfa for appellant.
Yes.
The release of amount in the
Mother Ankita minor. Sushma B mother has filed a complaint against. Who is a relative or no? Is some other person, not relative.
The check was issued in the name of the minor. Minor had an account. In the account.
How minor account can be issued by territory? Minor amount about the deposit. How minor account amount can be taken and given to some other person by the guardian?
The amount was in an FD. Then the guardian withdrew the amount and issued checks on it to the active. The loan amount is issued by way of checks.
Checks only.
He admitted. He admits receipt of the amount.
Okay.
He admits issuance of the check for
repay. No, the amount was for what purpose it was given?
For
Business. So amount was given through check. How much amount?
totally 6 lakhs. 2 checks.
Two cases, sir.
Okay.
Both
are connected.
Okay.
Apart from that, he had said that his property would be leased out.
Okay.
He would issue 9,000 as checks. He issued 11 checks for 11 months, 9,000 as interest part. Given those 11 checks were dissolved. Apart from this, the court told that because it's a minor's account, how mother has filed this complaint and rejected. In spite of their being admission that he admits that in the report also he has not paid it.
Tell it, where is the pending?
Pending also 40.
Our defense, what is their defense?
Actually, ಇಲ್ಲ ಸ್ವಾಮಿ ಯಾಕಂದ್ರೆ ಅವರು ಎರಡು ಸಲ ಇದ್ದಾರೆ ಚೆಕ್
ಅಲ್ಲ ಕೊಡುವಲ್ರಕ್ಕೆ ಕ್ರಾಸ್ ಗೀಸ್ ಮಾಡಾರಿಲ್ಲ ನಿಮ್ನ ಮಾಡಿ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಾರಲ್ಲ ಅವರು
ಹೌದು ನಾನು ಇವರಿಗೆ ಲೀಸ್ ಅಮೌಂಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳೋದು
ಲೀಸ್ ಅಮೌಂಟ್ಗೆ
ಲೀಸ್ ಕೊಡ್ತಾರೆ
ಲೀಸ್ ಅವ್ರು ತಗೊಂಡಾರ ಲೀಸ್ he has taken some property for lease. For that lease amount he has issued check ಅಂತ that is his defense, not the loan or borrowed.
That is also considered by the trial court. But some of the contrary to the findings.
No, not only on that ground, court has issued not only on that manner, except the denial of complaint has failed to issue the accused complaint of accused counsel support the conviction. That is a issue. Rejoinder. They have issued your legal notice. Reply also they have issued.
Because I have not issued a rejoinder.
He has admitted that as per demand notice issued to this accused, he has not been, covered. But the said two checks have been given to the complaint for repayment of the amount and execution check given to accused. They also belongs to him, but contents of checks are not going to be possible. Yen short point etide. Heard the learned counsel for the appellant and respondent counsel. ನಿಮ್ಮ ಹೆಸರೇನು ರಘು ಪ್ರಸಾದ್ ರೇ ರಘು ಪ್ರಸಾದ್ ಪಾರ್ಲರ್ ಕೌನ್ಸಿಲ್ BS ರಘು ಪ್ರಸಾದ್ ಈ RB ಸದಾಶಿವಪ್ಪ ಇಲ್ವಾ ಈಗ ಈ ಮೇಲ್ಗಡೆ ಬರ್ಕೊಳ್ಳಿ ದಿ ಆಫೀಸ್ ಟು ಶೋ ನೇಮ್ ಆಫ್ ಶ್ರೀ BS ರಘು ಪ್ರಸಾದ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ appellant and delete the name of Sri RB Sadashivappa. 12 and 12.1 ಎರಡರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಕಾಗಡ ದಿ heard learned counsel for the appellant and Sri Vasant Madhav the counsel responds to yes Vasant Madhav friend counsel ಹೆಸರು ಇದೆಯಲ್ಲ ಅಲ್ಲಿ counsel ಇದೆ on IA 1 of 20 I1 of 20. There is the appeal memo and impugned judgment for the reasons stated in that affidavit. I1 of 20 is allowed. Leave granted to the appellant to prosecute the appeal. Call for PCR. List this matter for admission. Yes. 12.1 same ala. 12.1 same. Yes. Rahul Rai ಬಂದಾರಲ್ರಿ ಇವತ್ತ ನಮ್ಮ ಜಸ್ಟಿಸ್ ಸೋಮಶೇಖರ್ ಸಾಹೇಬ್ ನಾವು ಡೌಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಹೆಸರು ಇಬ್ಬರದು ಏನ್ರಿ ಬಹಳ ದಿವಸ ಮೇಲೆ ಬಂದಾರ ಇವರು ಎಸ್ ಹೇಳಿ ಸರ್ ಬಹಳ ದಿವಸ ಮೇಲೆ ಬಂದಾರ ನಮ್ಮ ರಾಹುಲ್ ರೈ ಈ ಕಡೆ ಕಮ್ ಆಫ್ಟರ್ ಲಾಂಗ್ ಟೈಮ್ ಅಲ್ಲೇ ಹೋಗ್ತಾರ ಗೌರ್ಮೆಂಟ್ ಹೌದೇನು ಏ ಅಲ್ಲ ಪಾಪ ಅವ್ರಿಗೆ ಯಾಕೆ ಜೋಡಿಸ್ರಿ ನೀವು ಅವ್ರು ರಾಹುಲ್ ಬೇರೆ ಇವ್ರು ರಾಹುಲ್ ಬೇರೆ ನೀವು ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬಿಟ್ರಲ್ಲ ಅವ್ರು ಇವ್ರು ರಾಹುಲ್ ರೈ ಇವರು ಮಂಗಳೂರವ್ರು ಎಸ್ ಹೇಳಿ ಸರ್ ಏನಿದು
The contention taken by the defense other side is that the whom was received, whom was not received, the check was kept in the auto rickshaw.
ಎಷ್ಟು ಅಮೌಂಟ್ ಎಷ್ಟು ನೀವು ಎಷ್ಟು ಅಮೌಂಟ್ ಹೆಂಗ್ ಕೊಟ್ರಿ ಅವ್ರಿಗೆ
ಸೊ ನಾನು ಇದು ಏನಂತಾರೆ
ಅಲ್ಲ ಬೈ ಕ್ಯಾಶ್ ಕೊಟ್ರಾ ಬೈ RTGS ಕ್ಯಾಶ್ ಯಾಕೆ ಅವ್ರಿಗೆ ಏನಂತ ಇಲ್ಲ ಪೇಮೆಂಟ್ ಸ್ಟಾಪ್ಡ್ ಬೈ ಡ್ರೈವರ್ ಅಂತಿದೆ ಇನ್ಸಫಿಶಿಯಂಟ್ ಇರ್ತಿರ್ಲಿಲ್ಲ ಏನ್ ಎಕ್ಸಿಟ್ ಪಿಯೇಟ್ ಪೊಲೀಸ್ ಮುಂದೆ ಅಲ್ಲೇ ಪೊಲಿಟಿಷಿಯನ್ ಕರೆಸಿ ಬರ್ಸ್ಕೋಣ ಅವು ಎಲ್ಲ ಕೋರ್ಟ್ನಾಗ ನಾಳೆ ಪೊಲೀಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅವ್ರು ಬರ್ಕೊಂಡಿರ್ತಾರ ಪೊಲೀಸ್ ಇವ್ರೇನ್ ಹೇಳಿದಿಲ್ಲ ಡಿನೈ ಮಾಡ್ತಾರ ಪೊಲೀಸ್ ದುಡ್ಡು ಕೊಡ್ತೇನೆ ಅಂತ ಎಲ್ಲಾ ಪೊಲಿಟಿಷಿಯನ್ ನೀವು ಕರೆಸಿ ಬರ್ಸ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಎಲ್ಲಾರು ಕೊಡ್ಬೇಕಾಗತ್ತೆ
June 2016 is the payment and disputed check as per their stated 2017. But he says that no, on so and so date the check was kept in my auto rickshaw. My wife also paid the data. If that is so, why the checks were missing in the auto rickshaw basket? It is no company.
ಬ್ಯಾಂಕ್ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಕೊಟ್ಟಲ್ಲ ಎದಕ್ಕಿದ್ದೀವಿ ಬಾರ ಈ HS ಶಂಕರ್ ಅಂತದಲ್ರಿ ಅಲ್ಲಿ heard alert counsel for the appellant and respondent. There is the appeal memo and impugned judgment. For the reasons stated in the affidavit, I1 of 2019 is allowed. Special leave granted to prosecute the appeal. Call for TCR, list this matter for admission. ಬರ್ಲಿ TCR ಬರ್ಲಿ.
14, Jayaramu NN for appellant.
ಡಿಲೇ ಐತಲ್ರಿ, ಡಿಲೇ ಕರೆಕ್ಟ್. ಡಿಲೇ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. Appellant counsel present issue notice of I-1 of 2023 regarding condonation of delay to respondent. Call for TCR on.
Call it Dismissal.
ಯಾರು ನೋಡಿದ್ರೆ ಯಾರು ಬರ್ತಾ ಇದಾರೆ? ಬರ್ತಾ ಇದಾರೆ ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲಿ ಪ್ರೆಸೆಂಟೇಷನ್ ಇದು ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ. I-1 is dismissed. No ground that appeals in time. Council option, no open for the appellant. I-1 dismissal not possible. Last chance, 2 weeks time. Okay. That's it. No representation for appellant. To stop the order sheet shows there is no representation for appellant continuously. To stop, if there is no representation for appellant, the appeal will be dismissed. This matter after 3 weeks. Bandra check it. Appeal substitution complied. Last chance in the no reference for appellant. No reference for appellant. $23.
Number 16, Babu Clear Claim.
Yes.
The main condition taken out by the accused that no transaction has been taken place between the accused and the complainant. The transaction must be taken by the accused husband and the complainant, as per the evidence taken by the accused. The amount has been transferred to the accused husband here.
Accused husband
For the doing business of jewelry shop. The accused and as well as the accused husband was looking after the business. They both approached for the amount on the frequent dates. It has been
so you are transferred through the account of husband. Now repayment, who has paid the check? Wife has paid. Wife has issued check.
Wife issued the check.
No, what is their defense? What is their defense?
That no transaction has been taken place between the accused and the complainant.
But why she has issued the check?
they not taken the defense. ತಗೊಂಡಿಲ್ಲ ಅವ್ರು.
ಅಲ್ರಿ ಚೆಕ್ ಕೊಟ್ಟಾರ ಇಲ್ರಿ ಅವ್ರು ಯಾಕೆ ಕೊಟ್ಟು ಅಂತ ಹೇಳ್ತಾರ ಚೆಕ್
ಅದು ಹೆಚ್ಚು ಆಧಾರ ನೋಡಿ. ಇದು stated to the direction of
ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಯಾರ ಅವ್ರು
ಮಾಡಿದ್ದಾರೆ.
ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ ನೋಟಿಸ್ಗೆ
ಹಸ್ಬೆಂಡ್ ಕಡೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪಾಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿದ್ದಾರೆ ಚೆಕ್ ಹ್ಯಾಸ್ ಬೀನ್ ಇಶ್ಯೂಡ್ ಆನ್ ದಿ ಡೇಟ್ ಡೆತ್ ಆಫ್ ಹಸ್ಬೆಂಡ್ ಇರೋದು. ಹಸ್ಬೆಂಡ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ, ಅದಾದ್ಮೇಲೆ 3 ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ. ಅಪ್ಯೂಸ್ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ 3 ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ. ಅದು ಫೋನ್ ಪೇ ಆಗಿದೆ. ಕಂಪನಿಯಿಂದ 1 lakh ಹೋಗಿದೆ ಅವರಿಗೆ. ಫೋನ್ ಮಾಡಿದ ತಕ್ಷಣ ಏನಿದ್ದಾರೆ, ನಮ್ಮ ಹಸ್ಬೆಂಡ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ, ಅಮೌಂಟ್ ಬೇಕು ಅಂದಿದ್ದಾರೆ. ಇದೆಲ್ಲ ಲಂಸಮಾಗಿ ಒಂದು ಚೆಕ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಮಾಡಿದ್ರು. ಆ 1 lakh ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ಮೇಲೆ ವಿತಿನ್ 50 ಡೇಸ್ ಆದ್ಮೇಲೆ 1 lakh ಫೋನ್ ಪೇ after the death of husband. Despite of that, the child was not present at the transaction.
ನೀವು ಯಾರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ರೆ ಅವ್ನು ಸತ್ತು ಹೋಗ್ಬಿಟ್ಟ.
They called me, collect the amount.
Order records heard alert counsel for the appellant. There is the appeal memo and impute judgment. For the reasons stated in the affidavit, I-1 of 2022 is allowed. Special leave to prosecute appeal granted. Issue notice to respondent and call for TCR. Place this matter for admission. Yes. Correct. Just delay there. I-1 is for convention of delay. I-2 of 20 issue notice of I-1 of 2022 regarding condemnation of delay to respondent. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಪ್ರೆಸೆಂಟ್ ಅಂತ ಮಂಜುನಾಥ 1 of 2022 and call for TCR also. Yes. ಯಾದಕ್ಕೆ both the courts appeal ಹೆಂಗ appeal acquittal ಇಲ್ಲೇ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು ವೆರಿಫೈಡ್ ದಿ appeal ಸೆಕೆಂಡ್ appeal ಎಲ್ಲ ಹಾಕಿದ್ರಿ ಅವರೊಂದು ಹಾಕಿದ್ರು ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ತಿರುಗಿ ಸಿಸಿ ಯಾವ ಇಯರ್ದಿದ 2015 ಆಲ್ರೆಡಿ 7 years ಆಗೋತು ಸರ್ ಇದು ಏನು ಅಡ್ಮಿಷನ್ ಹೆಂಗ್ ಮಾಡೋದು ಏನಂತ ಇವಾಗ ಸುಮ್ಮನೆ ಆಲ್ರೆಡಿ 2 courts the house trespass it all depends upon the nature of transaction ಅದು ಈಗ ನಮ್ಮ ಮನೆಯಾಗ ಪರಿಚಯ ಇದ್ದವರು ಅವ್ರು ಬಂದ್ರ ಏನಾಯ್ತು ಏನೋ ಕೇಳಕ್ ಬಂದ್ರೆ ಬರ್ತಾರ ಏನೋ ಗೊತ್ತಿಲ್ಲದವ್ರು ಹೇಳಾರ್ದು ಏನೋ ಅಫೆನ್ಸ್ ಮಾಡಕ್ ಇಂಟೆನ್ಷನ್ಲಿ ಬಂದ್ರ ಟ್ರೆಸ್ಪಾಸ್ ಆಗ್ತದೆ ಬೇರೆ ಏನೋ ಕೇಳಕ್ ಹೋಗಿ ಅದಕ್ಕೆ ಜಗ ಆದ್ರ ಮನೆಗೆ ಹೋದ್ರ ಅದು ಟ್ರೆಸ್ಪಾಸ್ ಆಗುದಿಲ್ಲ ವಿತ್ ದ ಇಂಟೆಂಟ್ ಟು ಕಮಿಟ್ ಸಮ್ ಅಫೆನ್ಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಎಂಟರ್ ದಿ ಹೌಸ್ ನೀವು ಅದೆಲ್ಲ ಬಿಟ್ಟು ಎಲ್ಲಿ ಅಸಾಲ್ಟ್ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಇವ್ರು ಡಾಕ್ಟರ್ ರಘುತ್ತಮ ಅಬುಕ್ಕರ್ ಸುಮಾರು 20 ವರ್ಷ ಭೂ ವ್ಯವಹಾರನ ಒಟ್ಟಿಗೆ ನಡೆಸಿದ್ದು ಸ್ನೇಹಿತರಾಗಿದ್ದು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಫ್ರೆಂಡ್ಸ್ ಅವ್ರು ದೋಷ ಮತ್ ಹೆಂಗ ಟ್ರೆಸ್ಪಾಸ್ ಆಗತ್ರಿ ಇವ್ರ ಟೆನೆಂಟ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಇದ್ರ ದೋಷಣ ಪಟ್ಟಿ ಕಳಿಸಿದ ಆರೋಪಗಳು ಸಮಾನ ಉದ್ದೇಶದಿಂದ 25/11/2014 ಸುಮಾರು 4:15 ಗಂಟೆಗೆ ಪ್ರಕರಣದ ಫಿರ್ಯಾದಿದಾರರ ಮನೆಯ ಕಾಂಪೌಂಡಿನ ಒಳಗಡೆ ಆರೋಪಿ ಅಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ಅವಾಚ್ಯ ಶಬ್ದ ನಿಂದಿಸಿ ಮಂಗಳೂರು ನಗರದ ನೆಲ್ಲಿಕಾಯಿ ರಸ್ತೆ ಸಾಗರ ಕಟ್ಟಡ ತನಗೆ ಮಾರಾಟ ಮಾಡೋದು ಒತ್ತಾಯ ಹಾಕಿ ಮಾರಾಟ ಮಾಡೋದು ನಿನ್ನನ್ನು ಜೀವ ಬೆದರಿಕೆ ಹಾಕಿ ಮನೆಯ ಹೊರಗಡೆ ನಿಲ್ಲಿಸಿ ಫಿರ್ಯಾದಾರರ ಮನೆಯ ಕಾಂಪೌಂಡರ್ ನಿಲ್ಲಿಸಿ ತಾನು ಕಾಂಪೌಂಡರ್ ಪ್ರವೇಶಿಸಿ ಆರೋಪಿಯ ಮೇಲೆ ಕೃತ್ಯ ಎಸಗಿದ್ದಾನೆ. ಎಲ್ಲೈತೆ ಅಸಾಲ್ಟ್ ರೀ ಇವ್ರ ಅಲಿಗೇಷನ್ ಇಲ್ಲ, ಅಸಾಲ್ಟ್ ಅದ ಚಾರ್ಜೇ ಇಲ್ಲ. ಅದ್ ಲೈಫ್ ಥ್ರೆಟ್ ಅದು ಎಲ್ಲದಕ್ಕೂ ಲೈಫ್ ಥ್ರೆಟ್. ಎಲ್ಲರ ಬೇಕಲ್ಲ ಇದೆ ಇರುದೇ 6 ಜನ ವಿಟ್ನೆಸ್ 7 ಜನ ವಿಟ್ನೆಸ್ ದಾರ ಪ್ರಕರಣದ ಫಿರ್ಯಾದಿ ಯಾರೋ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ ಯಾರೋ ಗಂಡ ಹೆಂಡತಿ ಅವರೇ PW1 and 2 PW3 ಅಲ್ಲ ಕರೆಕ್ಟ್ ಇಲ್ಲ ಒಳಗ ಮನೆಯೊಳಗ ಘಟನೆ ನಡೆದ್ರೆ ಅವರೇ ಇಷ್ಟ ವಿಟ್ನೆಸ್ ಮತ್ತಾರು ವಿಟ್ನೆಸ್ ಇದ್ರು. ಎಕ್ಸಿಬಿಟ್ D1 ಮಾರ್ಕ್ ಆಗಿದೆ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್. ಸಿಕ್ಸ್ ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಅಲ್ರಿ ಅವರೇ ಕಾನ್ಸ್ಟೇಬಲ್ ಈಸ್ ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಶ್ರೀನಿವಾಸನ್ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ. ಆಯ್ತು ಸರ್, ಇದು ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಕೊಟ್ಟಾರ ನಿಮ್ಗೆ. 3-2 ಒಂದು ಡೇಟ್ ಕೇಳಿದಿರಿ ನೀವು. ನಾನು ಇಲ್ದಾಗ ಹೋಗಿ ಬಂದ್ ಹೋಗಿದ್ದೆ ನೋಡುವ. Applied counsel for the appellant seeks time. Applied counsel for the appellant seeks time. Appellant counsel seeks time. Every time ನೋಡಿ ಇದೆ. Applied counsel for the appellant present physically before the court and seeks time. Weeks time. The applied counsel for the appellant seeks time. 2 weeks time granted. ಹಂಗ ಬರ್ತಾನೆ ಇದೆ ಅದು. Two weeks time granted at the request of notice. 2 weeks time granted. ಯಾವಾಗ ಆಯ್ತು ನೋಟಿಸ್? 2 weeks time granted. 31. ಇಶ್ಯೂ ನೋಟಿಸ್. ಅದಾದ್ಮೇಲೆ 19-2 ಬಂದಿದೆ. ಅಪಲೆಂಟ್ ಪ್ಲೇಸ್ ಟೈಮ್. ದೆನ್ 3-2 21 ಬಂದಿದೆ ಒಮ್ಮೆ. ಆಮ್ಯಾಗ 3-2 ಬಂದಿದೆ. ಮತ್ತೆ ಇವಾಗ 10-2 ಬಂದಿದೆ. ಮತ್ತೆ ಇವತ್ತು 3 ಸಲ ನೀವೇ ಕೇಳಿದ್ರಿ ಡೇಟ್. ಇವತ್ತು ಯಾವ ಕೇಸ್ ಇಲ್ರಿ ಜಾಸ್ತಿ ನಮ್ಗೆ. ಅದು ಫ್ರೈಡೆ ಬೆಂಚ್ ಇರ್ತಾವ್ ಮಾಡಿದ್ವಿ. ಫ್ರೈಡೆ ಯಾವ ಬೆಂಚ್ ಮಾಡಿಲ್ಲ ನಮ್ದು ಇವತ್ತು. ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಒಂದು ಇಲ್ಲ. ನಾನು ಫ್ರೈಡೆ ಬೆಂಚ್ ಇರುತ್ತೆ ಇವ್ರಿಗೆ ಕಡಿಮೆ ಹಾಕಿ ಅಂದೆ. ಅವರು ಅದು ಬೆಂಚ್ ಇಲ್ಲ ನೋಡಿಲ್ಲ, ಕಡಿಮೆ ಹಾಕಿ ಮ್ಯಾಟರ್ಸ್. ನಾನು ಯೂಶಲಿ ಫ್ರೈಡೆ there will be benches. So I will not sit single in the afternoon. But board branch ಅವರು ಅದರ ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿಲ್ಲ ಅಂತ ಅವು ಎಷ್ಟು ಇದ್ದು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟಾಗಿ. ಈ 2 ಕನ್ಕರೆಂಟ್ ಆದ್ಮೇಲೆ ಅಲ್ಲ ಅಪಲೆಂಟ್ ಈಗ ವಿಕ್ಟಿಮ್ ವೆದರ್ ಅಗೇನ್ ಅವರು ಅದಲ್ಲ ಅಲ್ಲ ಅಗೇನ್ಸ್ಟ್ acquittal ಈ ಸೆಷನ್ ಕೋರ್ಟ್ಗೆ ಯಾಕೆ ಹೋಯ್ತದ ಮ್ಯಾಟರ್? ಕರೆಕ್ಟ್. ಅಗೇನ್ಸ್ಟ್ acquittal ಸ್ಟೇಟ್ ಎಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಅಪ್ಪೀಲ್? ಇಲ್ಲ ಅಲ್ಲ ಕರೆಕ್ಟ್. ಬಟ್ ವೈ ಇಟ್ ವಾಸ್ ಪ್ರಿಫರ್ಡ್ 378 ಅಲ್ಲ 378 appeal in case of acquittal. Okay. Also direct the public prosecutor to present an appeal to the Court of Sessions from an order of acquittal passed by magistrate in respect of cognizable and non-bailable offense. Sessions Court, yeah. But ಇಲ್ಲಿ ಯಾವುದು? To the High Court from the appellate order and acquittal order passed by any court other than the High Court or an order of acquittal passed by Court of Sessions. Cognizable. No, but ಇಲ್ಲಿ appeal ಆಗ್ತಿರಲ್ಲ ನೀವು. ಈಗ 498 ಅವೆಲ್ಲ ಆಗ್ತಿರಲ್ಲ ಅವು 306. ಓಕೆ ಓಕೆ ಅವು ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಇಂದ ಇಲ್ಲಿ ಬಂದಿರ್ತಾವ ಹಾಸ್ಪಿಟಲ್. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಇಂದ ಬಂದ್ರೆ ಹಾಕುದಿಲ್ಲ ಡೈರೆಕ್ಟ್. ಓನ್ಲಿ ಸೆಷನ್ಸ್ ಕೇಸಸ್ ಅಗೇನ್ಸ್ಟ್ ಸೆಷನ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇಲ್ಲಿ ಆಗ್ತೀರ ನೀವು ಅಲ್ವಾ? ದಟ್ಸ್ ವಾಟ್ ಐ ಥಿಂಕ್. ಬಟ್ NI Act cases, if such an order is acquittal is passed, in any case issued upon a complaint, ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಬರ್ತದೆ. An application made to it by complaint in this behalf grant a special leave to appeal for an order to acquittal. The complaint may present such appeal to High Court. So NI Act special leave ಹಾಕಿ ಇಲ್ಲಿ ಹಾಕ್ತಾರೆ. They open to the High Court to re-appreciate the evidence. And 2 years are possible, appellate court not reverse the judgment. ಈ 18 ಅಂದ್ರೆ ನೋಡಿ ಸರ್ 5 years ಆಗೋದು. Appellant counsel ಆಗಿದೆಯಾ? ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ವಿಚಾರ? Appellant counsel present, respondent counsel also present. Appellant counsel prays for short time. The appeal is nearly ಯಾವ ಸ್ಟೇಜ್ಗೆ ಇಟ್ಟಿದೆ? 3 years. Appeal is more than 4 years. Third, call for TCR. Appeal admitted. This matter for final hearing. Appeal admitted. Final hearing ಇಟ್ಬಿಡ್ತೇನೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂದ್ರೆ ಬರೋದಿಲ್ಲ, ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ನಾಗ ಇಟ್ಬಿಡೋದು. ಇಲ್ಲ ಅಂದ್ರ ಏನಿಲ್ಲ ನೋಡಿ ಇವ್ರ ಸುಮ್ಮನೆ ಇದು ಟೆನೆಂಟ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಕೆಳಗೆ ಜಗಳ ಏನ ಟ್ರೆಸ್ ಪಾಸು ಆಗುದಿಲ್ಲ ಅಲ್ಲ, ಅದೆಲ್ಲ ಬೇರೆ ಕೇಸ್ ಹಾಕುದು. ಈ ಫೈನ್ 448 2 ಕೋರ್ಟ್ ಆಲ್ರೆಡಿ ಪೆಂಡಿಂಗ್ ಕೊಟ್ಟಿದೆ. ಕ್ರಿಮಿನಲ್ ಲಾ ಸಿಂಪ್ಲಿ ಬಿಕಾಸ್ ಅದರ್ ವ್ಯೂ ಇಸ್ ಪಾಸಿಬಲ್, ದಿಸ್ ಕೋರ್ಟ್ ವಿಲ್ ನಾಟ್ ಟೇಕ್ another view even if there is another view. ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಕಾಲ್ ಫಾರ್ TCR ಟೆಲಿಫೋನಿಕಲಿ. ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡಿಬಿಡಿಪ್ಪ. ಎಸ್, ಮತ್ತ ಇವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ರಿ, ಸ್ಟೇಟ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಸ್ಟೇಟ್ ಅನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಲ್ಲ. When the said earlier case is on the basis of state, complaint is the state ಅಲ್ಲೇ ಅವಾಗ ಅಲ್ವಾ? ದಿ appellate ಅದೊಂದು ಬರ್ಕೊಳ್ಳಿ, ಡೌಟ್ ಇದೆಯಾ? The appeal is pending for nearly more than 4 years. ಬರ್ಕೊಳ್ತಪ್ಪ, it is seen ಬರ್ಕೊಳ್ಳಿ ಕೆಳಗಡೆ that the trial, before the trial court, the state is a complaint, and against the acquittal, the state filed an appeal before the session court, which also came to be dismissed. Therefore, the appellant shall make state as a formal party as respond number 4. 4 and amend the file an application to include respond number 4 as a formal party state. ಮಾಡ್ಬಿಡಿ ಅದನ್ನೊಂದು. Yes. ಪ್ರದೀಪ ಅಲ್ವಾ ಎಲ್ಲರೂ ಆಯ್ತು ಹೇಳಿದೆ ಒಮ್ಮೆ ಬರೋದು. Yes. 29/4/2013. Yes. Okay.
Parking the road along.
Road.
This sustained she died on the day.
Parents ಗೆ ಏನಾಗಿಲ್ಲ.
ಏನಾಗಿಲ್ಲ ಬರೀ ಮಗು ಮಾತ್ರ ಗಾಡಿ one is the father.
PW1. Yes.
PW2 and 3 are the other.
Yes.
The PW2 even are the merger with it. They are not supported.
Yes.
PW6 is the ESI not registered the case. And the PW8 is the owner of the accused was driving the jeep. PW9 is the IO melon who filed.
Yes.
But the evidence of PW1 is protected.
Yes.
Where is the
Annamalai. Yes.
ಶಾಸ 2ರಿಂದ 5ರವರ ಪರಿಚಯ ಇದೆ. ಅನುರಾಧ ನನ್ನ ಮಗಳು. ಸುಮಾರು 1.5 ವರ್ಷದ ಹಿಂದೆ ನಾನು ಮಾಲಾ ಸ್ಟೇಟ್ನಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದೆ. ಸುಮಾರು 1.5 ವರ್ಷದ ಹಿಂದೆ ನಾನು ನನ್ನ ಹೆಂಡತಿ ಮತ್ತು ನನ್ನ ಬಹುಮಾಲಾ ಎಸ್ಟೇಟ್ನಿಂದ ನಮ್ಮ ಕುಟುಂಬದ ಇಲ್ಲಿ ಗಾಡಿ ಹತ್ತಲು ಬಸ್ ನಿಲ್ದಾಣಕ್ಕೆ ಬರುತ್ತಿದ್ದೇವೆ. ಜನ್ನಾಪುರದ ಬಸ್ ನಿಲ್ದಾಣದ ಹತ್ತಿರ ರಸ್ತೆಯನ್ನು ದಾಟುತ್ತಿರುವಾಗ ಒಂದು ಜೀಪ್ ಬಂದು ನನ್ನ ಮಗಳಿಗೆ ಡಿಕ್ಕಿತು. ನನ್ನ ಮಗಳ ತಲೆಯ ಭಾಗಕ್ಕೆ ನಂತರ ಅದೇ ಜೀಪಿನಲ್ಲಿ ಆಸ್ಪತ್ರೆಗೆ ನನ್ನ ಮಗಳನ್ನು ನ್ಯಾಯಾಲಯದ ಮುಂದಿನ ವಾರ ಆ ದಿವಸ ಈ ಜೀಪ್ ಅನ್ನು ಚಲಾಯಿಸುತ್ತದೆ. ಆರೋಪಿಯ ಜೀಪ್ ವೇಗವಾಗಿ ಬರುತ್ತದೆ.
Yes.
PW2 and 3 are the
Rajini. Yes. Yes.
the trial cannot
Yes.
reasons are stated in number 11.
Judgment of the trial. Yes. Page number.
Page number 6, my lord.
Yes.
Para number 11.
ರಸ 1 ಮತ್ತು 3.
ರಾಸ 1 ಮತ್ತು 3ರ ಸಾಕ್ಷ್ಯವನ್ನು ಅವಲೋಕಿಸಿದಾಗ ಸಾಕಷ್ಟು ವಿರೋಧಾಭಾಸಗಳು ಕಂಡುಬರುತ್ತವೆ. ಎಲ್ಲ 20 ರಿಂದ 30 ಜನರು ಬಸ್ ಬಂದಾಗ ಮಗುವೊಂದಕ್ಕೆ ಮಾತ್ರ ಅಪಘಾತವಾಗಿರುತ್ತದೆ. ಮಗುವೊಂದಕ್ಕೆ ಮಾತ್ರ ಯಾವ ರೀತಿ ಅಪಘಾತವಾಗಿರುತ್ತದೆ? ಗಡಿಬಿಡಿಯಲ್ಲಿ ಬಸ್ ಹೋದಾಗ ಬಸ್ ಒಂದು ಬದಿಯಿಂದ ಇನ್ನೊಂದು ಬದಿಗೆ ಪ್ರಯಾಣಿಕರು ಬಸ್ ಇಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಕೇವಲ ಆರೋಗ್ಯ ಅಪಘಾತವಾಯಿತು ಸ್ಪಷ್ಟವಾಗಿರುವುದು. ಮಗುವಿನ ತಂದೆ ಅಥವಾ ಇತರರು ಮಗುವನ್ನು ಸರಿಯಾದ ರೀತಿಯಲ್ಲಿ ರಸ್ತೆ ದಾಟಿಸಲು ವ್ಯವಸ್ಥೆ ಮಾಡಿದರೆ ಅಪಘಾತವನ್ನು ತಪ್ಪಿಸುತ್ತದೆ. ಆದರೂ ಸಹ ಅಪಘಾತವಾದ ನಂತರ AGPಯಲ್ಲಿ ಮಗುವನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತಾರೆ. ಏಕಾಏಕಿ ರಸ್ತೆಯನ್ನು ದಾಟುವಾಗ ಯಾವುದೇ ವ್ಯಕ್ತಿಗಳು ಅಡ್ಡ ಬಂದರೆ ಅಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಕೇವಲ ವಾಹನ ಚಾಲಕರ ಅಪಘಾತವಾಗುವುದು. ರಸ್ತೆ ದಾಟುವ ವ್ಯಕ್ತಿಗಳ ಅಪಘಾತ ಸ್ಥಳದಲ್ಲಿ ವಾಹನಗಳು ಪ್ರತ್ಯೇಕವಾಗಿ ಆದ್ದರಿಂದ ಪಾಠ 1 ರಿಂದ 3 ಇದೀಗ ಮತ್ತು ಜಾಗರೂಕತೆಯ ಚಾಲನೆ ಬಗ್ಗೆ ಪೂರಕವಾಗಿರುವುದಿಲ್ಲ.
Yes. Sketch produce ಮಾಡಿದ್ದಾರೆ ಸರಿ. ಎಲ್ಲಿ ಆಗಿದೆ ಆಕ್ಸಿಡೆಂಟ್? ರೋಡ್ ಮಧ್ಯ ಆದ್ರೆ ಮತ್ತ ಮುಂದೆ ಹಂಗ ಅದು ತಂದೆ ತಾಯಿ ಇದ್ದು ಪಾಪ ಮಗುವಿನ ಇವರು ಸರಿಯಾಗಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ಅದು ಸಡನ್ ಆಗಿ ಓಡಿ ಹೋಗಿರ್ತದೆ ಮಗು, ಗಾಡಿ ಬರ್ತಿರ್ತದೆ. ಇಟ್ಸ್ ಪ್ಯೂರ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್, ನಾಟ್ 304A. ರಕ್ತದ ನಿಶಾನೆ ಮಿಡಲ್ ಆಫ್ ದಿ ರೋಡ್. ಈ ಕಡೆ ಬಸ್ ಇದೆ, ಆ ಕಡೆ ಬಂದಾಗ ಓಡಿ ಹೊಂಟಾರ. ಹುಡುಗ ಸಣ್ಣ ಹುಡುಗ ಪಾಪ ಓಡೇ ಬಿಡ್ತಾ ಇರೋ ಅನ್ಫಾರ್ಚುನೇಟ್ ಇನ್ಸಿಡೆಂಟ್ ಹಾಕಲ್ಲ. ಓಕೆ, ಹರ್ಡ್ ಯಾಕೆ ಡೇಟ್ ಕೇಳ್ತಾ ಇದ್ರಿ ವಕೀಲ್ರೆ? ಡಿಸ್ಪೋಸ್ ಆಗಿ ಹೋಗ್ತದ ಮ್ಯಾಟರ್. ದಿಸ್ ಎಲ್ಲಿ? ಎಲ್ಲಿದೆ ಹಂಪು? ಯಾರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ? Who has admitted? The jeep was coming from which ಇದು? ಬೇಲೂರು ಟು ಸಕಲೇಶ್ಪುರ, ಗೋಣಿಬೀಡು, ಮೂಡಿಗೆರೆ ಈ ಕಡೆ. ಎಲ್ಲಿ ಬೇಲೂರು? ಬೇಲೂರು ರಸ್ತೆ ಇಲ್ಲ. ಅವರು ಊರಿಗೆ ಬೇಲೂರು ಹೋಗೋದು ಇರ್ಬೋದು, ಬಟ್ ವೇರ್ ಇಸ್ ದಿ ಬೇಲೂರು ರೋಡ್ ಯಾರ್? ಸರಿಯಾಗಿ ಗೋಣಿಬೀಡು.
ಬೇಲೂರಿನಿಂದ ಜನ್ನಾಪುರ ಸರ್ಕಲ್
ಕರೆಕ್ಟ್ ರೀ, ಅಲ್ಲೇ ಆಯ್ತು. ಬಟ್ ಅಡಿ ಎಲ್ಲಿ ಉಂಟು?
ಜನ್ನಾಪುರ ಸರ್ಕಲ್
ಚಾಲಕನು ಚಾಲನೆ ಮಾಡಿ ಜನ್ನಾಪುರ ಸರ್ಕಲ್ ಗೋಣಿಬೀಡು ಅಲ್ಲಿ ಅಪಘಾತ ಆಗಿದೆ. ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಜೀಪ್ ಎಲ್ಲಿ ಬರ್ತಾ ಇತ್ತು ಅಂತ? ಯಾವ ಕಡೆ? ಬೇಲೂರಲ್ಲಿ ರೋಡ್ ಯಾವ ಕಡೆ? ಬೇಲೂರು ಬರ್ತೈತೆ. ಬೇಲೂರು ಈ ಕಡೆ ಗೋಣಿಬೀಡು. ಬೇಲೂರ್ ಕಡೆ ಹೋಗೋ ಬಸ್ ಅಂತ ಅಂದ್ರೆ ಮೂಡಿಗೆರೆಗೆ ಹತ್ತದೈತೆ ಅವ್ರ ಬಸ್. ಮೂಡಿಗೆರೆ ಆದ್ಮೇಲೆ ಬೇಲೂರು ಹೋಗುತ್ತೆ. ಬೇಲೂರ್ ಕಡೆ ಬಸ್ಸು ನಾನು ಗೋಣಿಬೀಡು ಕಡೆಯಿಂದ ಗೋಣಿಬೀಡು ಈ ಕಡೆಯಿಂದ ಬಂದದು. ಗೋಣಿಬೀಡು ಕಡೆಯಿಂದ ಬಂದದ್ದು. ಇವ್ರು ಈ ಕಡೆ ಹೋಗ್ತಾ ಇದ್ರು. ಎಲ್ಲಿ ಹಂಪೆಲ್ಲಿದೆ ಅಂತ ಇದ್ರಿ ಇವರು? ಬಿಡ್ಬಿಡಿ ಒನ್ನ. ಇಲ್ಲ ಅಂತ ಹೇಳ್ಯಾರ ಅವ್ರು. ಯಾರ್ದು ಓದ್ತಾ ಇದೀರಿ? ಜಜ್ಮೆಂಟ್. ಯಾರ? ಓಕೆ. ಮತ್ ಯಾವ್ದೋ ಒಂದು ಡಿಸಿಷನ್ ಹಾಕಿರಲ್ಲ. ಸ್ಪೀಡ್. ಜಜ್ಮೆಂಟ್ ಗೊತ್ತಿಲ್ಲ. This appeal arises out of the judgment of acquittal passed by additional civil judge and JMFC. Additional civil judge and JMFC Mudigere in CC number 424 up to 13, wherein the respondent accused was acquitted for the offences punishable under section 279 and 304A of Indian Penal Code, recognized hereinafter shortly referred as IPC. IPC. Next column. The brief, next paragraph. The brief case of the prosecution is that On 29/4/2013, at about 1 p.m., PW1 was with her daughter, came near Jannapur circle. Full stop. They intend to proceed to Belur. At that time, madam, while crossing the road, the respondent, being a driver of offending vehicle, that is Jeep, bearing registration number KA 15N-7077, drove the vehicle in a rash and negligent manner so as to endanger human life and dash to the minor daughter of PW1 by name Kumari Anuradha. Full stop. Due to the said impact, Anuradha sustained grievous injuries. She was immediately shifted to hospital. But on the way to hospital, she succumbed to the injuries. In this regard, a complaint was registered at Gonibidu police station against the accused. The police investigated the case and filed charge sheet against the accused for the offence stated above. Next paragraph. The prosecution in all examined 9 witnesses as PW 1 to 9 and got marked 10 documents as exhibit P1 to P10. Full stop. After recording statement of accused under section 313 CRPC and hearing the arguments, learned JMFC acquitted the accused. Full stop. Agreed by the same, the state has filed this appeal. Next paragraph. Heard, learned SCGP or for state and Sri Pradeep HS, Sri Pradeep HS, learned counsel for the respondent. ಅದು ಬೇರೆ ಪ್ಯಾರಾ ಸೆಪರೇಟ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ. The learned HCGP argued that the impugned judgment and order of acquittal passed by learned magistrate is contrary to law, facts, and evidence on record. The learned magistrate has not appreciated the evidence properly. Full stop. PW1, the mother of the deceased and the eyewitness has clearly stated that the accused came in a high speed and dashed to the minor girl in a negligent manner. The place of accident took place in a road. ಏನ್ ಮಾತಾಡ್ತಾರೆ ಯಾರೊಬ್ರು ನಿಲ್ಸ್ಬೇಕಲ್ಲಿ ಪೊಲೀಸರು ಏನಂತ the place where the accident took place is a the place where the accident took place is a road, and there is also a bus stand. Always there will be crowd to stop. The driver of offending vehicle ought to have taken care to drive the vehicle with caution. Courtal pune illenri madam, courtal pune badli yarange hakara door hakant theatre ಹಾಕಂತ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೋಗಿ ಎಲ್ಲೂ ಡೋರ್ ಹಾಕೇ ಬಿಟ್ರು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬೇಡ ಅಂತೇಳಿ ಕೋರ್ಟ್ ಹಾಕಿ ಏನ್ ಮಾಡೋದು ಯಾರೊಬ್ರು ಯಾಕ್ರಿ ರಜಾ ಹಾಕ್ಯಾರ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇವ್ರು ಆಗಲೇ ಕೋರ್ಟ್ ಪ್ಯೂನು ನಮ್ಗೆ ರಜಾ ಹಾಕಿದ್ದ ಇವತ್ತು ರಜಾ ಹಾಕ್ಯಾರ ಎಲ್ಲ ರಜಾ ಹಾಕ್ಬೋದಲ್ಲ ಯಾಕೆ ಬದ್ಲಿ ಯಾರನ್ನ ಡೆಪ್ಯೂಟ್ ಮಾಡಂತ ಇರ್ಲಿ ಯಾರು somebody should be here. ಇರ್ಬೇಕಿಲ್ಲ ಗಲಾಟೆ ಮಾಡ್ಕೊಂಡು ಏನಾಗ್ತದೆ caution. The deceased was a minor girl aged about 5 years. The trial court failed to appreciate the evidence of PW 1 to 3 who have fully supported the prosecution case. Therefore, the reasons assigned by the magistrate are erroneous and improper. Hence, the impugned order of acquittal is contrary to law, perverse, and liable to be set aside. Accordingly, the SC period to set aside the judgment of acquittal and convict the accused in accordance with law. Against this, the learned counsel for respondent, Sri so and so, argued that the place where the accident took place, there was a crossroad which goes to one to Sakleshpura and another to Bonibidu, and the road passes towards Mudigere. The scene of offense, Panchanama and sketch map produced by the prosecution clearly shows the accident took place in the middle of the road. To stop. Admittedly, the parents of the child were with the minor child. They have taken, they ought to have taken care to see that while crossing the road, no vehicle is coming from either side of the road. It appears they have left the child and suddenly the child came on the road without noticing the vehicle and the accident occurred. Full stop. There is nothing in the evidence of prosecution, witnesses to show that the accused drove Off recording. Alva, now it's if it happens, recording will. Today again it happened. Only one day, Friday, and that day not to ensure that. Yes, yeah.
Totally they were 13%. They were
Waiting for the bus. And immediately after the bus came, they all crossed the road to other side. They all tried to cross the road to go to other side of the road to catch the bus. And when they were crossing the road to board the bus standing on the other side of the road, this accident occurred. He has also admitted that the place of accident is a circle and there are 3 roads joining to the said circle. Of course, she has denied a suggestion that there was no such humps near this circle. She has denied a suggestion that when they are crossing the road, the child fell down on the road and they left the child on the road itself. At that time, the accident occurred. It is suggested that they were not taking care to take the minor child of 5 years with them, and accident occurred because of their negligence in leaving the child on the road itself and crossing the road without looking into the vehicles. Next, PW2 Rajini. Is another witness who was also accompanying PW1. She was also waiting for the bus. And she has also said that the bus came and dashed the child. Then they took the child to the hospital. So her evidence also shows that while crossing the road, the said accident occurred. They have also admitted that there were about 30 persons waiting for the bus, and they were all waiting near the door of the bus. They could not see whether any vehicles were coming on the road. The deceased is a relative. even before the bus stop, when they were crossing, when they tried to cross the road by running to catch the bus, the accident occurred. Yes, expressed her ignorance regarding any humps near the place of accident. They also admitted that immediately when the bus came, they all crossed. PW3 Satish was also stated similar evidence, stating that when they were crossing the road, the jeep came in a speed and dashed to the end road. His cross-examination also reveals that there are all about 30 persons and they crossed the road to catch the bus which came at that time. They were crossing from right side to left side. They also admitted that there was a circle and there was a cross curve. They also admitted the vehicles could not come in a high speed in that circle. So his evidence will also not help the prosecution. PW4 Shukumar, the Pancha witness, he has not supported the prosecution. Similar is PW5 DK Krishnagoda, is a Pancha witness for place of accident. He has and also seizure of vehicle. He has also not supported the prosecution. Full stop. The prosecution has treated both these witnesses as hostile witness and cross-examined them, but nothing helpful to the prosecution is elicited in their cross-examination. Next, PW6 Revanna, the PSI, who has received the complaint and reached the case, which visited the hospital and conducted inquest Panchanama. PW7 Ramesh is another eyewitness. He is and also inquest Pancha. He has not supported the prosecution. PW8 Ramesh Goda is the owner of the ZG. PW9 R Ramesh, the circle inspector, who has conducted the investigation and filed the charge sheet. The cross-examination, he has admitted that the Belur-Jannapur road is a national highway and number of vehicles will be passing daily. He has also admitted that he visited the spot of accident after 24 hours. He has also admitted that there are no marks of any accident on the road. He has denied a suggestion that none of the witnesses understand Kannada and they all speak Tamil. He has denied it. On the other hand, the evidence before court shows that the witness have given evidence in Tamil language, which was translated and what written in the language of the court. So that itself shows that IO has not properly investigated or recorded the statement of the witnesses. Next, sir. Next, on there is in the evidence of fresh witnesses and the spot panchanama, exhibit P2 and sketch exhibit P8. It is evident that the accident occurred in the middle of the road. It is also evident that about 30 persons were standing on the other side of the road waiting for the bus. When the bus came, they all tried to cross the road to catch the bus on the other side. It is also evident that these parents of the deceased, along with their other child, they are carrying their luggages also and crossing the road. It appears they have not taken care of the said child, which was only about 5 years old, and left it in a hurry to cross the road, and this unfortunate accident occurred. The way in which the accident occurred, the place in which the circumstances in which the said accident took place clearly shows that the parents of the child, without seeing the vehicle coming on either side of the road, have suddenly tried to cross the road by running, and in the said event, they have left the small minor child, and the child might have tried to cross the road without looking the vehicle coming and met with the accident. To stop simply because an accident occurred, there is no presumption that it was only due to rash and negligent driving of the driver of the vehicle. The prosecution has to prove the rash and negligent driving and show before the court that the accident occurred due to the rash and negligent driving of the driver of the offending vehicle. The learned expert, the trial judge, after considering the evidence and relying on the judgment of Bombay High Court, reported in the year 1971, Bombay, page 164, has held that the prosecution has failed to prove guilt of the accused beyond all reasonable doubt, hence given benefit of doubt to the accused. In view of the discussion made above, I find no ground to interfere with the judgment of acquittal passed by the trial court. The said judgment is neither perverse nor erroneous. Next para. It is settled principle of law. This court, being a appellate court, will not interfere in the judgment of acquittal unless it is shown that the said judgment, being perverse, has resulted in miscarriage of justice. In view of the said principles, if the impugned judgment is considered, I find that the appeal being devoid of merits is liable to be dismissed. Accordingly, the following order, the appeal is thereby dismissed. Judgment of acquittal passed by the Learned JMFC Mudgere in CC number so and so is so and so dated so and so is hereby confirmed. Send back the records to the trial court. The bond, if any, executed by the AP stands cancelled. Yes, appeal dismissed.
21, accused Subramania for appellant.
You are for? Sorry, file. ಬೆಳಿಗ್ಗೆ ಈ ಸೈಡ್ ಆನ್ ಮಾಡಿಲ್ಲ ನಾವು ಬೆಳಿಗ್ಗೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಲ್ಲ ಈ ಸೈಡ್ ರಿಪೋರ್ಟ್ ಹಾಕೊಂಡು ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಕರೆಕ್ಟ್ ಆಗಿ ಚೆಕ್ ಮಾಡಿಪ್ಪ ಅವ್ರು ಬಂದಾಗ ಒಮ್ಮೆ ಅವ್ರು ಸರಿಯಾಗಿ ಏನು ನೋಡ್ತಾ ಇಲ್ಲ ಹಂಗ ಅದು ಆನ್ ಇರಲಿಲ್ಲ ಬೆಳಿಗ್ಗೆ ನಾನು ಈಗ ಮಧ್ಯಾಹ್ನ ಈಗ ಮಾಡಿರೋದು ಅಂದ್ರೆ they should not put it. Old CC 2008 matter 50,000 rupees 8 and 8 10 plus 15 years I got 50,000 rupees only the matter is of 50,000 it is pending for more than 15 years. Oh. Yes, you must argue the matter, sir. Morning, this was not on, madam. Left side. New on madi langa hogbitru. Huh? No, morning in the irle like it was not there. Morning I see only portal number 29. Nodi properly ella maadi idella not correct. At least you must check before ಬರೋಕ್ಕಿಂತ ಮುಂಚೆ ನೋಡಿ ಎಲ್ಲ ರೆಡಿ ಇಟ್ಕೊಳ್ಳೋದು ಸ್ಟಾರ್ಟ್ ಫ್ರೈಡೇ ಆಗ್ಬಾರ್ದು ಓನ್ಲಿ ಇರುದೇ ಹಾಫ್ ಡೇ ಇರ್ತದೆ ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ಇರ್ಲಿ ಫ್ರೈಡೇ ಆಲ್ಸೋ ನಾಟ್ ವರ್ಕಿಂಗ್ ಅಂದ್ರೆ ಮಾರ್ನಿಂಗ್ ಅವ್ರು ಯಾರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ರೆಕಾರ್ಡ್ ಆಗಿಲ್ಲ ಅದು ಟಿ.ಪಿ ಅದು ಯಾರು ಕಂಡೇ ಇಲ್ಲ ಅದು ಇಲ್ಲ ಇಲ್ಲಿ ಕಂಡಿಲ್ಲ ಅದು ಇಲ್ಲ check dated 23/10/2007 for 50,000. Against acquittal, you preferred a revision, huh? Revision. Appellant counsel absent, respondent counsel present. New appellant, huh? ನಿಮ್ಮ ಹೆಸರೇನು? You are for? ನಿಮ್ಮ ಹೆಸರೇನು? Sri Bharat, third counsel for the appellant counsel present and rest I am stating that. Here reason in, what is the reason? ಅದೆಲ್ಲ ಬರುದಿಲ್ಲ. There is not a ground stating that the file is misplaced. Such a ground cannot be accepted at all. The respondent counsel also absent. The appellant counsel shall argue the matter as the appeal itself is more than 12 years old. In the ends of justice, the time granted finally is a last chance. 23/3 as a last chance. ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ ನೋಡ್ರಿ ಅವತ್ತು ನೀವು ಬಂದಿಲ್ಲ ಅಂತ 23/3 yes.
22, for appellant. Yes.
Who is for appellant? ಉಮೇಶ್ ಬಂದಿರ್ತಾರಲ್ಲ RB ದೇಶಪಾಂಡೆ ಸರಿ ಏನು ವಾಟ್ ಇಸ್ ದಿಸ್ ಚೆಕ್ ಅಮೌಂಟ್?
It's a check amount for 10 lakhs.
Hmm.
It's a complainant's appeal. But, yeah, let's have to comment the arguments, madam. The respondents were acquitted members by the Honorable Trial Court.
Yes.
For various reasons, madam. In fact, the appellants failed to prove that there existed any legal recoverable debt as a primary reason in the courts.
Yes.
And subsequently, there are various other reasons, my lord. If my lords may kindly grant me an opportunity, this will be for 2 weeks' time, my lord. I should do so because I just see the file, my lord. Here. My lord, may kindly present page number 10 of the judgment, my lord.
Yes. Purchase of shares.
Is the contention of the appellant's money. But my lords may kindly peruse 12th line from the bottom, my lords. In
Yes.
page number 10. It starts with he has admitted affair. If my lords may kindly permit me to.
He has admitted that he does not have any contract,
Yes, my lord.
note or counterfile.
Yes, my lord. When he does not have relevant documents to even showcase as to an alleged share transaction can occur.
Yes.
Which means there exists no such legal recoverable debt. It says that it was a primary source of purchase as well as a secondary source of purchase. For a primary source of purchase, there must be certain counterparts. And for a secondary source, there must be a contract note. Both of which he
RB ದೇಶಪಾಂಡೆ ಅವರು ಉಮೇಶ್ ನೋಡಿ ಎಲ್ಲದರು ಕಶ್ಯ ಏನಿದೆ ಇದ್ರು ಏನಿಲ್ಲ ಅಲ್ಲಿ ಶೇರ್ಸ್ ಅಂತ ಹೇಳ್ತಾರ 10 ಲಕ್ಷ ಹತ್ರ 2.5 ಲಕ್ಷ ಕೊಡ್ಬೇಕಂತಾರ ಸುಧಾಶಿವನಗರ RB ದೇಶಪಾಂಡೆ 82 ಅವರೆಲ್ಲ ಅದರ ಇವರು ಉಮೇಶ್ ಬರ್ತಾರಲ್ಲ ಕೇಸ್ order sheet. Yes, I see.
It says the first line paragraph number 12.
Matter is listed after longer time.
Yes, sir.
It was not at all listed. Eight years matter is not at all listed. Today first time it is coming. MD Raghunath and PS Shamil Ahmad. ನಿಮ್ಮ ಹೆಸರು Skanda Kumar. Once is Skanda Kumar. Counsel for representing respondent present. The appellant counsel absent. No representation. The appeal is more than 11 years old. the appellant counsel shall be present and argue the matter without fail. As the matter is not listed for nearly 8 years. In the ends of justice, time granted finally is the last chance for arguments. Place this matter on 27-3 as a last chance. You inform your other side also. Yes.
By 23. No further recording. Any petition?
There is a notice with the council. ನೋಡುತ್ತಾರೆ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಯಾಕೆ ಹೋಗ್ತದೆ ಯಾಕಂತ ಏನಾಯ್ತು ಇಶ್ಯೂ ಆಗಿದ್ದದು ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದ್ದು ಏನಾಗಿದೆ ಏನಾಯ್ತು ಯಾವಾಗಿದೆ
12/4/2022. Dispatched on 24th. But to not push the center.
ಬರಲಿ ಅವರು ಬ್ರಾಂಚ್ ಕರೆಸಿ ಕೇಳಿತ್ತು ಅವರು ಡಿಸ್ಪ್ಯಾಚ್ ಮುಂದೆ ಎಂತ ನೋಟಿಸ್ ಇದೆ ಎಲ್ಲಿ ಕಾಪಿಟರ್ ನೋಟ್ ಬೀಫ್ ಎಲ್ಲ ನೋಟ್ ತಗೋರು
12/4 ಅಲ್ಲಿ 2022.
ಹಾ ಇಶ್ಯೂ ಆಯ್ತು ನಿಂದ
ಅದಾದ್ಮೇಲೆ ಅವರು ಓಕೆ
next the learned counsel for the appellant absent. It is seen that one Sri KV Satish had filed wakalat, no wakalat for appellant. Thereafter, he has remained absent. The order sheet also shows that there is no representation for the appellant and the court has issued notice to counsel for the appellant. The office record shows that this is check 2 lakh. Office record shows that the notice was also dispatched to the counsel for appellant. There is no representation. Oh yeah, court notice also ಬರ್ತಾನೆ this court has issued notice, nobody is copying. Continuously 3 times. Even court notice also issued. ಯಾರು ಬರ್ತಾ ಇಲ್ಲ appellant. You are for appellant and respondent. The whole building, they will dismiss the appeal. Earlier one Muniappa was appearing. Subsequently in 2018, this learned counsel Sri KV CH-29 filed Okalat. Then he moved the memo, he remained absent. Again case was listed, again he remained absent. Court issued notice to him. He remained absent. Now who has to argue the matter? Avuru baralla. Matter is more than 10 years old. 2013 matter. I don't know whether parties are there, whether they are in contact with them, what instruction they have given. Advocate, they are not at all hearing for the appeals, more than 10 years old matters. Even court is not supposed to issue notice, but court has issued notice. In spite of that, no response. Yenadru? So it shows that appellant is not interested. Not interested in prosecuting the appeal. Respondent counsel Sri so and so is present. As the matter is more than 10 years old, is 10 years old. As there is nobody to argue the matter, no useful purpose will be served by keeping pending this appeal on the file of this court. Just to add another, just to show pendency. Therefore, the appeal is dismissed for non-prosecution. Good.
Number 24, all Krishnamurti shall appellate. Charity.
Sir, ಏನಿದೆ? Act. ಇಲ್ಲ ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಬಂದಿರಲ್ಲ ಬೆಳಿಗ್ಗೆ ಅವರು he was present. ಹೋಲ್ಬಿಟ್ರಿ ಮೇಡಮ್ ನಾವೇನ್ ಮಾಡ್ಬೇಕು, ನೀವ್ ಯಾಕೆ ಅವ್ರಿಗೆ ಹೇಳಕ್ ಹೋಗ್ತೀರಿ? ನೀವು ಡೋಂಟ್ ಟೆಲ್ ಅಬೌಟ್ ಅಡ್ವೊಕೇಟ್ಸ್. ದೇ ವಾಂಟ್ ಲೆಟ್ ದೆಮ್ ಕಮ್ ಏನ್ರಿ? ಎಸ್ ಏನ್ ಸರ್ ಇದು 138. What is the check amount?
Yes, 150, 152 text.
Two checks for 1,50,000 each. They were given for what purpose? Legal necessity, for improvement of departmental store. How they are given? It is by cash or by check? Cash. Why? Known to each other. Then they are dishonored.
Dishonored, notice was issued.
Funds insufficient. And legal notice sent. It is served.
Legal notice was filed. Notice was issued. The address given by the accused at the time of It's not son of Anand Babu. He don't need her. He did not with the notice and he was listening himself. But in the complaint, he has given he has mentioned the same address. Even in the appeal, he has mentioned the same address. Sorry, in the judgment also it is same address. He was in fact residing there. That is one of the contentions on which the
ಸುಧರಿ ಕಟ್ಟಡ ನಾನು ಶೇಖ್ ಅವರಿಂದ ಬಾಡಿಗೆ ತೆಗೆದುಕೊಂಡಿದ್ದೆ. ಆರೋಪಿ 3 ಲಕ್ಷ ರೂಪಾಯಿ ಸಾಲ ಒಂದು ತಿಂಗಳ ಮೊದಲೇ ಹಣ ಬೇಕೆಂದು ಕೇಳುತ್ತಾರೆ. ಆರೋಪಿ ಅಲ್ಲಿನ ಬೂತ್ ಎದುರುಗಡೆ ಅಂಗಡಿ ಇರುವುದು ನಮಗೆ ಪರಿಚಯ ಇರ್ತದೆ. ವಿಷಯ P1ರಲ್ಲಿ ಸಂಖ್ಯೆಗಳನ್ನು ಬಿಟ್ಟರೆ ಬರಹಗಳು ಬೇರೆ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ಏನು ಅಡ್ಮಿಷನ್ ಆರೋಪಿಗೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸ್ಟೋರ್ ನಡೆಸಲು ನನ್ನ ತಂದೆಯವರು ಬಂಡವಾಳ ಹಾಕುತ್ತಾರೆ. ಅಲ್ಲಿ 3 ವರ್ಷ ವ್ಯಾಪಾರ ಮಾಡಿರ್ತೇನೆ. ಆರೋಪಿಗೆ ನಾವು ಬಡ್ಡಿ ಮೇಲೆ ಹಣ ಕೊಡುವ ಆರೋಪಿಯನ್ನು ನಾವು ಚೆಕ್ ಬಿಟ್ಟರೆ ಬೇರೆ. ರಮೇಶ್ ನಾನು ಪಕ್ಕದ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಮಾಡ್ಕೊ ಆರೋಪಿ ನನ್ನ ಹಣ ಕೇಳಿದ ಬಳಿಕ 15 ದಿನ ನಂತರ ರಮೇಶ್ ಅವರಿಂದ ಹಣ ಕೇಳ್ತೇನೆ. ಈ ಬಗ್ಗೆ ರಮೇಶ್ ಅವರಿಗೆ ದಾಖಲೆ ಕೊಟ್ಟಿಲ್ಲ. ಮಿಷನ್ ಅಡಿ 2 ಸ್ಥಳವನ್ನು ಆರೋಪಿಗೆ ಬರೆದು ಕೊಟ್ಟಿದ್ದೇನೆ. ಅಂಗಡಿಯಲ್ಲಿ ಕೊಡುವಾಗ ಆರೋಪಿ ಕೊಟ್ಟಿದ್ದೇನೆ 25,000 ನಾನು ಮಾಲೀಕರಿಂದ ವಾಪಸ್ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ. ದೇರ್ ಆರ್ ಅಡ್ಮಿಷನ್ಸ್. ಅವರು ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದಾರ. ದೇ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್.
different transactions in the complaint. Current was running a department. That was sold to the accused. That is a totally different transactions, and the selling was finalized before the amount was lent. And actually, physically, the store was handed over to the accused after lending of the amount. But that is different. So far as these checks are concerned, the amount was lent by the company, whereby the accused promised he would repay within the amount. Doctor has given 2 checks. The checks and handwriting difference is different. Is a difference.
No, what is his difference? Accused difference, you know, what is his difference?
It's only different handwriting. They are almost. It is settled that the handwriting is different. Here, one important thing is the accused has not denied the signature.
No, how he say why the checks are come to you? To whom the check? Whether he admits in his evidence, he borrowed the loan and gave the check. That's what I'm asking. What is his difference? He must say when his checks are with you, he must say how those checks came into your hand.
My father.
To your father. For what purpose? For what purpose?
Different stores purchase madidike antare. Actually, checks were given by him to me, but he says the checks were given to my father. Your lordship may kindly see page
TCR
47, because this is the difference evidence matter. But he doesn't deny the signature. He doesn't deny having all the checks. I think check Indian vehicle now. Para 3 years not also. I do take oath and state that the complainant's father requested me to take a correction. Business of the account shows standing in the name of complainant, and that time land checks were taken from me, etc.
ಎಲ್ಲಿ ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಿ?
47 minutes.
47. Satish Kumar. I do take the complaint. Father requested me to take. This is not dependent. Blank checks were taken from me. The evidence of transaction complaint has handed over the lease agreement of shop. The owner of the building not allowed to run the business on the other hand. He has thrown away all the belongings. It is false that I issued 2 checks. I have not at all raised the interest in the given respect.
The humble submission is my lord.
No, you're not cross-examined him, na? ಇಲ್ಲ ಕ್ರಾಸ ಮಾಡಿಲ್ಲ ಏನು ನೋ ಕ್ರಾಸ ಪಾರ್ಟಿ ಸವಾಲು ಮುಂದೂಡಲಾಯಿತು ಕ್ರಾಸ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಟೇಕನ್ ಪ್ಲೇಸ್ ಒರಿಜಿನಲ್ ನೋಡುವ PW1 ಪೇಪರ್ ಬುಕ್ ಕರೆ ಮಾಡಿಲ್ಲ PW1 ಏನ್ ಹೆಸರು ಅವಂದ ವಾಟ್ ಇಸ್ ನೇಮ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇವರು DN ಮಂಜುನಾಥ್ ಇದಲ್ಲ ನಾಟ್ ಈಸ್ DW1 ಪೇಪರ್ ಬುಕ್ ನಲ್ಲಿ ಕ್ರಾಸ್ ಇಲ್ಲೇ ಅಲ್ರಿ ನಿಮ್ಗೆ ಯು ಗಾಟ್ ಡಿಪೋಸಿಷನ್
He has admitted that he has given the checks. Assuming for a moment, not admitting, that he has given the checks to my father.
ಅಲ್ಲ ಈಸ್ PW1 ಸತೀಶ್ ಕುಮಾರ್ ಅಕ್ಯೂಸ್ಡ್ ಮುಂದೆ PW1 DN ಮಂಜುನಾಥ್ ಇದು DN ಮಂಜುನಾಥ್ Satish Kumar. Where is the evidence of Satish Kumar? Original. Sixteen to 2012 ಅಂತಿದೆ ನೋಡ್ರಿ ಏನು 16 to 2012
ಅವರು ಹೇಳಿದ್ರೆ ನಿಜ ಅಂದ್ರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸ್ಟೋರ್ಸ್ ಅಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ ನಮ್ಮ ತಂದೆ ಕೊಟ್ಟರು ಅಂತ ನಿಜ ಅಂದ್ರೆ nothing prevents me from filing this appropriate case in the name of the father. My father ನನ್ನ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸ್ಟೋರ್ ಮಾಡಿದ್ದಾರೆ. Department store is run by me. For that, my father invested the money.
So he has sold it to him. So for that purpose, he has given check. ಆಯ್ತು ಅದಕ್ಕೆ ನಂದೇನು ಲಯಬಿಲಿಟಿ ಇಲ್ಲ
ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ದು ಲೆಂಡ್ ಮಾಡಿದ್ದು ಬೇರೆ. It's for different transactions. He is trying to link both the transactions.
ಕ್ರಾಸ್ ಇದೆ ಇಲ್ಲಿ ಸರಿಯಾಗಿ ಟೈಪ್ ಮಾಡಿಲ್ಲ ಇದು ಮುಂದ್ಗಡೆ ಈ ಪೇಜ್ನಾಗ ಇದೆ ನೀವು ನೋಡಿಲ್ವಾ ಕ್ರಾಸ್ ಇಲ್ಲಿ ಇದೆ ನೋಡಿ, ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಪೇಜ್ ಇದೆ ನೋಡಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ನೋಡಿ ಸರಿಯಾಗಿ ಇವರ ಪೇಪರ್ ಬುಕ್ ನಾವು ಕಳಿಸಿ ಹೇಳಿ ಹಿಂಗೆಲ್ಲ ಟೈಪ್ ಮಾಡಬಾರ್ದು. ಹರಿಸೇ ಬಿಟ್ಟಾರ ಅವರು ಆ ಡಿಪೋಸಿಷನ್ ಲಾಸ್ಟ್ ಪೇಜ್ ಅದೈತಲ್ಲ ಕ್ರಾಸ್ ಇದೆಯಾ ಒಂದು ಕ್ರಾಸ್ ಟೈಪ್ ಮಾಡಿಲ್ಲ ನೀವು ಪೇಪರ್ ಬುಕ್ ಮಾಡಿದ್ರೆ ಹೆಂಗಿದೆ ಇವ್ರು ಮಾಡಕ್ ಅಲ್ವಾ ನಿಮ್ ವಕೀಲರ ಯಾರು ಪೇಪರ್ ಬುಕ್ ಇಸ್ ಫೈಲ್ಡ್ ಬೈ ಯು ಪೇಪರ್ ಬುಕ್ ಇಸ್ ಫೈಲ್ಡ್ ಬೈ ಯು then who is the judgment deposition who has filed it this is this appellant K. Krishnamurthy you have filed this huh? No appeal memo this is in the here only depositions also here only you have filed depositions also there is everything that itself is not correct. The Karnataka counsel for the appellant present. It appears the paper book, the cross examination of PW1 is not forthcoming. The same shall be furnished by the 11th counsel of the accused. By the admit list what 216 ನಂತರ the 216 is admitted. Thereafter matter not listed at all.
28 January 2016.
It is not listed 16 ನಂತರ 92/16 ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಅಲ್ಲಿಂದ ಇಲ್ಲ 7 ವರ್ಷ ಆಗುತ್ತೆ ಇವರು ಅದರ್ ಸೈಡ್ ಯಾರೋ ಬೆಳಿಗ್ಗೆ ಬಂದಿದ್ರಲ್ಲ ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಂಬಡಿ ವಾಸ್ ಪ್ರೆಸೆಂಟ್ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ ಅರಿವೋಟ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ ಯಾರು ಚರಾಟಿ ಎಸ್ ಬಂದಿರೋರು he was present morning 10:30 today he was present and a short time I told him at his old let the appellant counsel come so ಅವ್ರಿಗೂ ಹೇಳಿ ನೀವು ಹೇಳಿವ್ರ ಅವ್ರಿಗೆ ಬರ್ಬೇಕಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಡುದಿಲ್ಲ ಗೊತ್ತಾಯ್ತಾ respondent counsel had raised time in the first session. The ends of justice time granted. Finally, as the matter is nearly 10 years old and it is lifted only after 7 years, the argument shall be advanced without fail on next date. Place this matter on 28/3. ಆಗ್ಬೋದ್ರಾ Hmm. 28/3 ಲಾಸ್ಟ್ ಆಗ್ತದೆ ಲಾಸ್ಟ್ ವೀಕ್ Second ಏನ್ ಇಸ್ ಹಾಲಿಡೇ ಓಕೆ ಓಕೆ Twenty-eight. 23. Next. No, that Cross-examination of
Is there the exam?
LCR, it is there. Just xerox it and
Apply and
certified copy and furnish it. It is there. It is there on the back side, but it appears only they have front side they have xeroxed and back side they are not xeroxed.
Other party has not contacted me.
ಹೌದಾ? ಅವ್ರದ್ದು ಕಾಂಟ್ಯಾಕ್ಟ್ ಇಲ್ಲ ಅಂತ ಅವ್ರೇನು ಐ ಡೋಂಟ್ ನೋ. ವಾಟ್ ಇಸ್ ದ ಚೆಕ್ ಅಮೌಂಟ್? 3 ಲಕ್ಷ. You don't know. Sometimes parties themselves settled.
No to me.
Okay.
So 2 years back he has
We ask him whether any matter is settled or whether they are not contacting each other. If it is not there, okay. If it is a matter is settled between them only, because for 1.5 lakh 3 years, 10 years, illé 10 years ಆಯ್ತು. ಅಲ್ಲೇ CC ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಗೊತ್ತಿಲ್ಲ. CC must be of earlier year.
2009.
2009.
4%.
ಸೊ 14 ವರ್ಷಕ್ಕೆ 1.5 ಲಕ್ಷ ಅಂದ್ರೆ ಬೆಲೆ ಬಹಳ ಕಡಿಮೆ. 10,000 ರೂಪಾಯಿನೂ ಆಗುದಿಲ್ಲ ಒಂದು ವರ್ಷಕ್ಕೆ.
Almost equal.
Okay, next.
Cell number 25, Yal Prakash. Referent CP Satish Chandra.
There. No representation for both sides. It is seen. I'm sorry, madam. It is seen that the matter is last posted in the year 2013. Thereafter, the matter is not listed. In the ends of justice, time granted, both counsels shall be present and argue the matter, as it is more than 10 years old. Place this matter on 29/3. Order to be put. ಸರಿ, ಮತ್ತೆ ಅವ್ರಿಗೆ ಏನ್ ಮಾಡಿ ಬರ್ದಿಲ್ಲ ಯಾಕೆ ಬರ್ದ್ರಿ? ಉಳ್ಕಿದ್ದು ಅವರು ಡ್ರಾಫ್ಟ್ ಅದಕ್ಕೆ ಏನ್ ಸಣ್ಣ ಸಣ್ಣ ನೋ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಡ್ರಾಫ್ಟ್ ಇಲ್ಲೇ ಬರ್ಬಿಟ್ರೆ ಆಯ್ತಪ್ಪ. ನೀವು ಹೇಳ್ಕೊಡ್ಬೇಕ್ರಿ ಇವ್ರು ಯಾರು ಇಲ್ಲಿ ಅದು ಇಲ್ಲೇ ಬಿಡ್ರಿ. ಮತ್ತೆ ಸುಮ್ಮನೆ ಮತ್ತ ನಾವು ಮಧ್ಯಾಹ್ನ ಇರುದಿಲ್ಲ ನೋಡಿ ಅವ್ರು ಕೇಳಿ ಆಗಿತ್ತಂದ ಇದ್ರೆ ತಗೊಂಬಂತ್ರಿ ಬೇಡ ಅಲ್ಲೇ ಖರ್ಚು ಮಾಡಕ್ ಹೋಗ್ಬಿಟ್ಟು ಬೇಗ ಬೇಕು ಮತ್ತೆ ಸಿಗ್ನೇಚರ್ ಸಲುವಾಗಿ ಮ್ಯಾಟರ್ ವಿಲ್ ಬಿ ಪೆಂಡಿಂಗ್. ಬೆಳಿಗ್ಗೆ ಎಲ್ಲ ಒಂದು ಡಿಕ್ಟೇಷನ್ ಬಿಟ್ರೆ ಎಲ್ಲ ಡೇಟ್ ಆಗ್ಯಾವ. ಐ ಥಿಂಕ್ 1 or 2 ಡಿಕ್ಟೇಷನ್ ಆಲ್ ಓನ್ಲಿ 10-15 ಮ್ಯಾಟರ್ಸ್. ಅವ್ರಿಗೆ ಬೇಗ ಕಳಿಸ್ಬಿಟ್ರೆ ಅವರು ಗೊತ್ತಾಗಿಲ್ಲ ಅವ್ರು ಕೇಳ್ತೇಳ್ರಿ ಮಾಡಿ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡ್ಬಿಡಿ. ಒಂದಿಷ್ಟು ಫಾರ್ಮೆಟ್ ಮಾಡಿ ಇಟ್ಬಿಡಿ. ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಬಿಟ್ಟು ಅವ್ರು ಕೊಟ್ಬಿಟ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. ಯಾರು ಬಂದ್ರು ಹೊಸದಾಗಿ ಕೊಟ್ಬಿಟ್ರೆ ಆಗೋಗ್ತದೆ ಅಲ್ವಾ? ಇದು ಆಫ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಸರಿಯಾಗಿ ಹೇಳ್ಬೇಕು ನೀವು. ಅದು ಸುಮ್ಮನೆ ಎಲ್ಲ ನಡುವೆ ಒಂದ್ ಸೈಡ್ ಬರೋದು, ಒಂದ್ ಸೈಡ್ ಕಟ್ ಆಗೋದು, ನಡುವೆ ಡಿಲಿಂಕ್ ಆಗೋದು.